And I don't care what she tells you. So there's no other discussion
That's what I
about it.
mean.
No other discussion. No contact, no communication, or your bond will be raised and you'll go back to jail.
Yes, ma'am.
That's how serious it is. You understand? Okay. 424, you're charged with the third-degree felony offense of continuous violence against a family member from February 6th of 2026. Since you've made bond in your case, have you had an opportunity to hire a lawyer? So what I'm going to do is reset your case about 30 days to give you some time to try to hire someone.
Okay.
If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer. They'll tell you what to do.
Thank you.
If you're unable to hire someone, I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to. So I know you're trying and we'll discuss what your options are. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order and you would go back to jail. Do you understand?
30 days.
I'm sorry?
30 days?
Yes, it'll be about 30 days.
Yes, ma'am.
So, as a condition of your bond, you understand that you cannot have any contact or communication at all with Cheryl Campbell. Do you understand?
Well, then she called me, what I told her, hang up.
Hang up. Because she's not going to go to jail. You are. Right?
She been calling me, but
Well, then hang up, because here's the thing. She cannot give you permission to violate my court order. So it's a condition of your bond that you have no contact or communication with her.
37 years, man.
I don't care how long it's been. Step in front of the court. Good morning. Are you Secretary Brown? And Mr. Brown, this is your initial appearance and cause number 26 DCCR 0607. You're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from September 21st of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, it is. I didn't know I had to hire one.
So what I'm going to do, once you make bond, I'm going to give you some time and expect you to try to hire a lawyer.
Okay.
So I'm going to reset your case for about 30 days to give you some time to try to hire someone.
Yes.
If you get someone hired before the next court date, bring the reset notice that you get today to that lawyer and they'll tell you what you need to do.
Yes, ma'am.
If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. You need to bring me the names of the lawyers that you've talked to when you come back, so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail. Do you understand?
Yes, ma'am.
And I'm looking at your indictment. It looks like you do have 2 sequenced felony priors, which means this is obviously a whole lot more serious than just that evading. You would be considered a habitual offender.
Some more priors.
Yeah, looks like you've got 2 priors from September 16th of 2015 for burglary of habitation. And then after that, an unlawful possession of a firearm by a felon in May of 2020 from Dallas County, Texas.
Oh yeah, that. But I'm done with that. I did prison time for this.
I understand, but what I'm telling you is because you have felony convictions, if you're found guilty on this one, it makes it a whole lot serious.
Okay.
It means that you would be considered a habitual offender with a minimum punishment of 25 years in prison, up to 99 years or life. So you need to get a lawyer hired before that next court date. Step in front of the clerk. She'll give you a reset notice.
Okay.
How can I tell? I never mind. I know. It's just really low for habitual, but I don't know if they see all that sometimes, you know?
Okay.
Richard Montalvo. Good morning. Are you Richard Montalvo?
Yes, ma'am.
And Mr. Montalvo, this is your initial appearance in cause number 26 DCCR 0448. You're charged with the state jail felony offense of fraudulent use or possession of identifying information. And that's from June 13th of 2025. And since you've made bond, did you have you had an opportunity to try to hire a lawyer?
No,
So what I'm going to do, Mr. Montalvo, is reset your case for about 30 days to give you some time to try to hire someone. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer. They'll tell you what to do.
yes, ma'am.
If you're unable to hire someone, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers you've talked to, so I know you're trying, and we'll discuss what your options are. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order. You would go back to jail. Do you understand? Step in front of the clerk. She'll give you a reset notice. Evelyn Odom. Good morning, ma'am. Are you Evelyn Odom?
Yes, ma'am.
And Ms. Odom, this is your initial appearance in cause number 26 DCCR 0403. You're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from February 8th of 2026. Since you've made bond, have you had an opportunity to try to hire a lawyer?
Spoke to him, I haven't heard him yet, but I did speak to him, right, and I'm probably just gonna hear right.
Okay, so what I'm going to do is reset your case for about 30 days to give you some time to either hire him or someone else. If you do get them hired, whoever, just bring the reset notice that you get today to that lawyer. They'll tell you what to do. If you're unable to hire someone, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, different payment plans. Bring me back the names of the lawyers you've talked to, so I know you're trying, and we'll discuss what your options are. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would go back to jail. Do you understand?
Yeah.
Yes, ma'am.
I was just listening. So if this is felony of 60, because you just tell the guy he's like at 25 to life, but it's third felony. Well, this isn't a third felony. That isn't, it was 16 years ago and 14 years before that.
It doesn't matter. If this is your third, then that could be a possibility. Yes, ma'am.
Okay.
Yeah.
Okay.
Yours, for some reason, is not listed on your indictment, but that doesn't mean that it's not, doesn't.
Just one was the clerk, maybe. I don't know. I'll talk to the lawyer.
Talk to your lawyer about that for sure. Yes, ma'am. Step in front of the clerk.
Okay, thank you.
Daryl Albritton. Good morning. You're Daryl Albritton. Did you get someone hired?
Well, he went up on this price because the other guys, they had stopped paying them. They paid them the 200. So now he went up to 750. So I'm got 410K. So I gotta go through a verification and take my money out to hire a lawyer.
To take your money out of what? I'm sorry.
401K.
Okay.
Because I just found out I had 401K.
So you've been coming here literally for almost a year.
I know. I got things. I gotta go back off. So I can't keep coming to court every month.
Yeah, you're going to come to court every single month until
Yes,
your
ma'am.
case is taken care of, and you're going to hire a lawyer.
Yes,
If you've got a good job and you're going offshore, then you need to get someone hired. Right?
Yes, ma'am.
So I'm going to reset your case 2 weeks. You need to get someone hired before that 2 weeks, or you need to bring me proof of the paperwork for that you're waiting on some money for 40. Walk in with something that shows me what you're doing. Otherwise, you're going to end up in jail. You understand?
Yes.
Step in front of the clerk. Nathaniel Campbell. Casey Kincaid. Good morning, sir. Are you Casey Kincaid? And Mr. Kincaid, this is your initial appearance and cause number 26 DCCR 0641. You're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle. And that is from February 6th of 2026. Since you've made bond, have you had an opportunity to try to hire a lawyer? Speak up.
Say no now, but I will.
Okay, so you're in the same position. I don't know if you were in here before. You've got 2 prior felony offenses that are sequenced. And so this is obviously a whole lot more serious than just that 3rd-degree felony. So I'll reset your case about 30 days to give you some time to try to hire someone. If you get them hired, just bring the reset notice you get to them. They'll tell you what to do. If you're unable to hire someone, you need to visit with at least 3 lawyers. I'm ordering you to do that. They all charge different amounts, different payment plans. Bring me those names so I know who you're talking to. Then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order and you go back to jail. You understand? All right, step in front of the clerk. Need a button that I push. That just says what I say.
I was just thinking that.
I know. But I'm not going to not say it because nobody can ever come in and say I didn't tell them. Akaya Nash.
Good morning.
Good morning. You're Akaya Nash.
Yes, ma'am.
Did you get someone hired, Miss Nash?
No, ma'am, I talked over, but I lost my job, or maybe it's like 2 pricing.
Who'd you talk to?
Miss Brittany Holmes, Jason Dix, and Mr. Ralph Campbell.
Okay, well, thank you for doing what I asked you to do, Miss Nash. I'm going to have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer.
Yes,
You need to make sure and fill it out accurately and completely because you're going to swear under oath that it's all true and correct, and then I'll take a look at it.
ma'am.
Step in front of the clerk on the end and she'll give you that paperwork. Kendrick Simeon?
He's in custody, Judge.
Okay,
Yeah, one.
thank you. Charles Toussaint? Thank you.
Yes, ma'am.
That's good. It's electric. Oh, was that the one that had to go?
Oh.
Mike, do we need to slide that table? Sorry, sir. Right up here. Good morning. Are you Charles Toussaint?
Yes, ma'am.
And Mr. Toussaint, this is your initial appearance and cause number 26 DCCR 0527. You're charged with a 3rd-degree felony offense of unlawful possession of a firearm by a felon from January 23rd of 2026. Since you've made bond in your case, have you had I gave you a medical PR bond, didn't I? So are you working? Are you able to work?
No.
Okay, so what I'm going to do this morning, Mr. Toussaint, is have you fill out some paperwork to see if you qualify for a court-appointed lawyer. You need to make sure you fill it out accurately and completely.
Legally blind.
You're legally blind. So let's just do this. I'll find that you qualify for a court-appointed lawyer. If you'll just come over here in front of the clerk, she's going to let you know who that is and how to get in touch with them. Okay, and then she'll give you a reset for your court date as well. Yes, sir.
That much.
You know, hopefully, do something you'll do, so we can do.
Brian Herrera Gonzalez.
Morning, Julia.
Good morning. You're Brian Herrera Gonzalez.
Yes, ma'am.
Mr. Gonzalez, did you get someone hired?
Yes, ma'am. I hired Benjamin Jeffers.
Okay, is he supposed to be here this morning?
Yes, well, he sent you, I think he sent something to them. Like the email.
When did you hire him?
Late afternoon on Friday.
Okay,
the 29th.
it probably hasn't come through yet. I don't see it, but sometimes when they send something on Friday, it doesn't get through the whole system by now. So let's do this. I'm gonna go ahead and have you fill out a reset for about 30 days. Make sure you take that to Mr. Jeffries. And
Okay.
between now and then, he'll probably get a different court date. But unless you get a different court date from him, come on the date that you've got.
Yes, ma'am.
Is there, Ms. Malfino, did you have something?
No, I just wanted to check on something.
Okay.
This is a case that transferred to me from CDC. I believe I've got the co-defendant and now.
Okay,
If I caught the name correctly.
okay.
I just want-
Thank you, ma'am. So, did you hear all that? It's just up in front of the clerk. He said he's already hired him, but it was Friday afternoon, so I don't see anything. Let's just do a normal reset and then, just make sure.
Upstairs.
Okay,
Maybe on.
yeah, just give him that reset and it'll probably be a different court date,
Okay.
but just double check with him first and your bondsman.
Sunday.
Travis Hingston. Good morning, sir. Are you Travis Hingston?
Yes.
And Mr. Hingston, this is your initial appearance in cause number 25 DCCR 1180. You're charged with the third-degree felony offense of tampering or fabricating physical evidence from August 28th of 2024. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer? Right. So when you're in custody, we automatically give you a court-appointed lawyer. Now that you've bonded out, I expect you to try to hire your own. So what I'm going to do is reset your case about 30 days to give you some time to hire someone. If you get someone hired before that next court date, bring the reset notice and to that lawyer, they'll tell you what to do. If you're unable to hire someone, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me the names of the lawyers you've talked to when you come back, so I know you're trying, and then we'll discuss what your options are. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would go back to jail. Do you understand?
Yes.
Okay, and it looks like you also have 2 prior felony convictions on your indictment, which obviously makes this a whole lot more serious. It means you would be considered a habitual offender potentially with a minimum 25 years in prison punishment up to 99 years or life. So it's very important you get someone hired. Are you chewing gum? Please don't chew gum when you come back next time. All right, step in front of the clerk. Terrence Jenkins. Good morning. Are you Terrence Jenkins?
Yes.
And Mr. Jenkins, this is your initial appearance and cause number 26 DCCR 0512. You're charged with a second-degree felony offense of aggravated assault with a deadly weapon, and that's from March 5th of 2026. And since you've made bond, did you have an opportunity to try to hire a lawyer?
I contacted Franklin Law Firm and Parker's. They gave me the estimate price, but when I got arrested, I kind of lost my job. So I found a new job. I'm supposed to get on schedule this week, so I
Good.
can kind of see where it goes from there.
Okay, perfect. So what I'll do is reset your case about 30 days to give you some time to try to hire a lawyer and also obviously save up some money. If you get someone hired, bring the reset notice that you get today to that lawyer. They'll tell you what to do.
Yes.
But if you're unable to before that next court date, start talking to more, talk to at least 3 others, bring me those names. So I know you're trying. They all charge different amounts, different payment plans. And then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that order, and you would go back to jail. You understand?
Yes.
All right, step in front of the clerk. She'll give you a reset notice. Got a bunch of initials. Jerry Dickert.
Yeah, thank you.
Oh, that's right. Forgot that.
Good morning,
Good morning. Are you Jerry Dickert?
Gary.
Gary Dickert?
Yes, ma'am.
And Mr. Dickert, this is your initial appearance in cause number 26 DCCR 0616. You're charged with a first-degree felony offense of possession of child pornography from May 28th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
I was actually given a court-appointed attorney while I was still incarcerated, but I've not had a chance to meet with him yet.
So here's what happens. Once you make bond in your case, I expect you to try to hire your own lawyer. So I'm going to reset your case for about 30 days to give you some time to hire someone. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before that next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers that you've talked to, so I know you're trying, and then we'll discuss what your options are. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would go back to jail. Do you understand?
I do.
All right, step in front of the clerk. She'll give you a reset
Can I
notice.
ask a question? There's a second charge as well. I think to,
There is, correct, sir. Sexual assault from, in clause number 26 DCCR 0617. And so that is a second degree felony offense. And from, January 1st of 2023 is the offense date in that case. Same thing applies. You need to make sure whoever you talk to knows that there are both of those cases. All right, step in front of the clerk.
thank you.
Javon Johnson. Javon Johnson. Javon Johnson. One that's been cutting and hasn't missed. Mhm.
Javon Johnson, we have support today. I'm 100% nice about it. That might take some use.
No response, Sean.
No. All right, their bond will be forfeited for non-appearance and reset at 100,000. Travion Patterson.
And now you're talking.
Good morning, sir. Are you Travion Patterson?
Yes, ma'am.
And Mr. Patterson, this is your initial appearance in cause number 26 DCCR 0521. You're charged with the third degree felony offense of obstruction or retaliation from March 4th of 2026. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, ma'am.
So what I'm going to do, Mr. Patterson, is reset your case for about 30 days to give you some time to hire a lawyer. If you get someone hired before the next court date, then just bring the reset notice that you get today to that lawyer and they'll tell you what to do.
Yes.
If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers.
Yes.
They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to, so I know you're trying, and then we'll discuss what your options are. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order and you to go back to jail. Do you understand? Hang on just a second. Let me take a look at something before you go. If I test you this morning, you gonna have anything in your system? I have a seat in the jury box. We're gonna get you tested this morning.
I think she will have.
That's Patterson. Brad Thibodeau. Good morning, you're Brad Thibodeau.
Yes, ma'am.
And Mr. Thibodeau, did you get someone hired?
No, ma'am. I
Who'd you talk to?
I'm trying to get a job right now. But I did get the job, but I didn't have my certification. I had to recertify it. Yes, I could take it again this month.
So what lawyers have you talked to since you've started coming?
Billy.
Any?
Talked to the owner.
Who? Why didn't you write that down and bring it? That's exactly what I told you to do. Talk to 3 lawyers, bring me their names so that I know you're trying. I say the same thing. You've heard it 14 times already this morning.
Didn't get that. I thought I was gonna get a job and be able to pay for my own lawyer. But I mean.
I understand, but so the last reset on May 11th specifically said proof of talking to attorneys at the bottom of it. And it said, I reset you for 2 weeks to bring proof of getting an attorney. But we've already had this conversation and what would happen. right? I don't understand why you wouldn't talk to some attorneys. That's all you had to do. Try to get a job, which it sounds like you're at least working on that, maybe, but you didn't. So you're not working. So you have plenty of time to at least call lawyers, see what they charge, to know what, if for no other reason, so you stay out of jail.
I talked to one of them, he said 2,500.
Three lawyers. I told you had 2 weeks to talk to 3 lawyers. Okay. At this time, I'm going to find that you violated the order of the court. I'm going to raise your bond because of that to $25,000. You can go back with the bailiff. Just make something up.
Or. I'll check the rest.
Locks hang on. Okay. Kyle Whittington. Good morning, sir. You're Kyle Whittington. And Mr. Whittington, did you get a lawyer hired?
Oh, hired Sonny Eckert.
You did hire him?
Yeah, for hiring. He asked for we did a 60-day reset. He's in the courtroom next door to a murder case or something like that. So.
Okay. Do you actually pay him or you're going to pay him?
We're going to pay him. We're paying him. Like we're hiring him.
When? I don't do 60-day resets.
I think it's gonna be like in a week. We're gonna pay him $10,000 up front, and then we're gonna be paying them on payment, of course.
So what I'll do, I'm gonna reset your case one more time. So this will be the final reset for you to get Mr. Eckert hired. Once he's hired, he'll send over some paperwork. So stay in touch with him, bring him this reset notice so he knows when your next court date is. And you guys can get him hired before that next court date.
Sounds good.
Okay, step in front of the car. You got that, Sonny Eckert, right?
Yes.
Mr. Macon on Aaron Wars.
Yes, John.
Aaron Wars.
Very much.
Aaron Wars. Aaron Wars. He's night. He tested positive for TBSI.
I'm sorry, what? Sorry.
Yeah.
Yeah.
Are you Aaron Wars? What's the matter? Why are you so tired?
Didn't sleep early.
What have you taken? What are you on right now? I'm going to test you so you can go ahead and tell me, or you don't lie. You're not on anything. So when you went to probation, you were on something right? So you're not on anything right now. Have a seat in the jury box.
Monday morning.
I know. I could see from here.
Good morning.
Good morning, Mr. Macon.
Have the excuse, I have other courts.
Yeah, if you'll just come back in a little bit, once we get them tested, we'll see what we're gonna do today. It's none of that. See, Mr. Lewis, you have Brissa De Hoyos. Morning. Mr. Smith, Brissa De Hoyos. Good morning. Good morning, ma'am. Are you Brissa de Hoyos? And this is cause number 25 DCCR 1622. Ms. de Hoyos is charged with aggravated assault with a deadly weapon. And what is the announcement?
Judge, I've gotten an offer from the state, which I have a feeling that it's gonna resolve this issue, but there is one more video that she has not seen yet.
Okay.
So I would like to reset so she can see that.
All right, we'll do one more. We'll do one more reset. It's very important. Call, make an appointment, go visit with Mr. Lewis so you can see everything that he has and make a decision on what you want to do with your case at the next court date. Okay. All right. You're free to go. And then, yes. Let me wait a minute on. Roderick James.
He's sitting right out.
This is gonna be. Mr. Smith, this is yours on Roderick James. Good morning, sir.
Good morning, man.
You're Roderick James. And this is cause numbers 26 DCCR 0388. Mr. James is charged with assault on a peace officer, and 26 DCCR 0389 also charged with assault on a peace officer. I'm going to take judicial notice of the court's file. Mr. James was evaluated by Dr. Hamza for competency to stand trial. I've received that report. It is dated May 12th of 2026. And in that report, the finding is that Mr. James is currently not competent to stand trial. Is there any other evidence with regard to competency?
No, Judge. Nothing stand.
Then at this time, I am going to find, Mr. James, that you're not competent at this time to stand trial. Find that inpatient competency restoration is needed, and order that you are to go to an inpatient treatment for a period of not to exceed 120 days from the day you get there for competency restoration. So you're going to go to a hospital. They're going to get you some help so you understand everything that's going on, and then we'll get you back and go through your case. Okay. All right. You can go back with the bailiff. He's going to take you to the back. So no on first. Yeah. Presley Viltz.
We hold on that one, Judge.
Sure.
It's gonna be.
Okay, I'll hold it. Thank you, sir. Mr. Paget, looks like you're working on something.
I have one that's been turned in.
Are you working on another one? Sarah Kennedy.
I'm doing my best.
Sorry.
Absolutely. Well, yeah, personally.
I do.
Right.
Good morning, Your
Good morning. Good morning, ma'am. Are you Sarah Kennedy? Yes. And will your client waive the formal reading of the indictment?
She will, Your Honor. You speak up so she can hear you over there, okay?
And Ms. Kennedy, and clause number 25 DCCR 1463, you're charged with the second-degree felony offense of assault on a peace officer from September 11th of 2025. Since you made bond, said that too many times this morning. How do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Paget? Do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine. You would be required to follow all of the rules and conditions of probation. In addition, there would be a dismissal in the misdemeanor case, cause number 25 CCCR 2945. Is that your understanding? Yes. Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objections to state's 1, Your Honor.
It's admitted. Is there any evidence that Ms. Kennedy is not competent?
None, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that we can get the probation department to do a pre-sentence report. That'll just give me more information about you and your case, and then we'll come back later for sentencing. Yes. On your way out of the courtroom this morning, you need to stop and talk to probation, and she's sitting at that desk right over there. So stop and talk to her on your way out, and then we'll see you at sentencing. All right, you're free to go. Let's see, what about Daniel Martinez, Mr. Paget? Daniel Martinez? Good morning, sir. You're Daniel Martinez, and this is cause number 25 DCCR 1414. Mr. Martinez is charged with aggravated assault with a deadly weapon. And what is the announcement?
Your Honor, we've received all the discovery, and this morning I've received an offer. If you would just give us a short period of time for me to go over it with him, I think the case is going to work out. I'm almost certain.
Okay, I'll reset it one more time. This will be the last one. It looks like you were hired back in December. So
Well, I'll go ahead and make this statement. It will be disposed of when we come back.
that's, I mean, whether it is or isn't, doesn't matter.
Fair.
It's either disposed of or go to the trial.
I understand.
But
Absolutely.
we just need an announcement at that next court.
For sure.
Make sure you visit with Mr. Paget before your next court date so you can go over everything with him, and then we'll get an announcement at the next court date. All right, you're free to go, sir.
Thank you. Put it right outside.
And what about Darius Jack?
Mr. Jack, come forward. Good shot.
See, this is Mr. Coleman's. Good morning, sir. You're Darius Jack.
Yes, ma'am.
And Mr. Jack is charged with a violation of a protective order in cause number 25 DCCR 1624. And what is the announcement?
The same announcement, Your Honor. We've received an offer, and I wasn't able to negotiate. Mr. Coleman sent me an offer on Friday, and Mr. Nichols has negotiated with me just a little bit. I relayed the offer to my client now, and he's asking for a 30-day reset to make his decision on whether he goes forward.
So, Mr. Jack, I'm going to reset your case, and this will be the last reset for an announcement. If you have any questions, make sure you make an appointment, visit with Mr. Paget. Y'all go over everything, and we'll get an announcement at the next court date, okay? All right, you're free to go, sir.
Thank you, Your Honor.
Thank you.
Can I have an excuse?
Yes, sir.
Thank you. Y'all have a good day.
Let's see, is it Mr. Charles Neesmith? Mr. Burbank, you've got Jalen Eli. Good morning, you're Jalen Eli?
Yes, sir.
This is cause number 25 DCCR 1004. Mr. Eli is charged with forgery of a financial instrument. And what is the announcement?
Your Honor, it's going to be a plea. It's a restitution case. He lost his job. He just got hired back on with the railroad, so he's going to be able to make amends. I asked just for one reset so we can get all money.
Okay, sounds good. We'll just do a normal reset, Mr. Eli. Take care of whatever you need to between now and that next court date, and then we'll see what we get taken care of on that date, okay?
Yes.
All right, you're free to go. Thank you.
Excuse me.
Yes, sir. Mr. Kelly? Okay, thank you. Mr. Kimler,
Yes, Your Honor.
are you working on, do you, Brianna Bell?
Mr. Cole's not here, he could make offer, you know, I was gonna negotiate it with him before and he's not here.
Well, that's what a 30-day reset for. All this waiting until the last minute to negotiate.
Second, you know, over the weekend.
Is Mr. Coleman not gonna be here today, or is he just running behind?
He's in another court. They drop it to Frida first, she probably would take it. It's true.
That's not for me to,
I'll discuss it a little bit with Mr. Cameron, see if we can work it out.
if not, that's fine. I'll reset it for 1 week. I'll hold it for now. And then what about Ashley Broussard, Mr. Kimler?
I'll defer to the state, you know.
We filed dismissal in the 67.
All right, is she here? Ashley Broussard, you're free to go, ma'am. I'm signing a dismissal on your case. Everybody will take one of those, huh? And Julissa Cortez Estrada.
I'm deciding that.
Okay, I'll take care of it as soon as it comes through. Malik Ellis, Mr. Kimler.
I told that one, at least present,
Justin Payne.
told that one also. Very good.
Cortez Estrada. I'm about
Did
to sign that one.
Yeah.
Thank you, ma'am.
Man, go behind.
Thank you, Dwayne.
Let's see, I saw Buddy, Mr. Reynolds, is he? And have we seen Mr. Wilkerson? Yeah. Deal with this real quick. Mr. Patterson? Mr. Patterson, when's the last time you smoked marijuana? It's important that you tell me the truth because you're going to end up wearing a drug patch and it's going to give me the amounts. And so I need to know so that I know about what to expect if that happens.
5 days ago.
Okay. So first of all, what made you think that was a good idea to do before you were coming to felony court?
I found out, I didn't find out about my court dates the last minute though when I checked in on my bill bonds.
But you knew it was coming because you had a bail bondsman. And you know it's illegal and a condition of your bond that you not do anything illegal. So it really doesn't matter when your court date is. It's not about timing it out so you test negative. It's about following the rules so you don't go to jail and eventually don't go to prison.
Yeah.
Does that make sense? How old are you?
Fine.
You're 23. So it's time to make some grown-up decisions. So here's what I'm going to do, Mr. Patterson. I'm going to order that you have a drug patch put on. You have 24 hours to have a drug patch put on. Your bondsman can tell you where to get that done. You've got to keep it on. You've got to get it changed every 2 weeks like you're supposed to. You have to pay for it. If it tests, the first one I know is going to test positive. The second one will probably still test positive, but it better be going down substantially. If it's not going down, I'm going to assume you're still using. There will be a bond increase and you will not get out of jail. Do you understand? If it comes off and is not testable, I'm going to consider that that's a positive. So whatever you have to do to keep that drug patch on, do it. Some people come in, they make excuses. Oh, it fell off, so it's not testable. It's not that hard to keep it on for every 2 weeks. And then you're going to get your reset to get an attorney and do everything you're supposed to do that I already talked to you about. Okay. All right. 24 hours and they'll send us proof of that.
Ivor Okay.
Unfortunately. True, that's passion.
Do you have another case, Mr. Patterson, in another court?
No, he does have a
Yeah.
One second.
One second.
All right, go back with the bailiff. And Mr. Patterson, the same thing applies if you bond out on that, all the conditions I just told you. That's okay. He thought he was gone. Uh-huh. So close. Let's see. Reynolds. Mr. Kelly, are you ready on Jeremy Chapman?
Please.
Let's get him over.
I don't see I have it yet. I'll hold it
Send
till,
it to,
okay,
I just sent it.
okay, we'll take care of it in just a minute.
Notes it. She knows. Yeah. Mr. Warren.
I think he went. I
Huh?
think he just went.
Oh, really?
Place my ears don't see. Save. They may not have been.
I'm gonna recall the bond forfeiture and Javon Johnson and reset that for 2 weeks.
That one.
See, Ms. Holmes, you have Aiden Dickinson, that's the sentencing. Aiden.
I need to, it might have came late, 'cause I had to go over the piece, so.
Oh, do you want me to hold it?
Yeah, I went over it with Brian Battle, I went over the piece.
Okay,
Yeah, I didn't
I'll
see
hold it
Aiden
like-
out there.
okay. Let's see, she's,
He's here.
okay, I'll hold it so y'all can go over
Okay.
that. Mr. Dickinson, you can just have a seat for a minute. Ms. Holmes is gonna come go over your PSI in just a second with you. And, let's see, got another one.
Yes, ma'am.
Brian Battle. Sentencing.
Miller. Think. My one paper.
Good morning, sir. You're Brian Battle. Good. And, Mr. Battle was previously here in court, entered a plea of guilty in clause number 25 DCCRs 1050 to evading arrest or detention with a motor vehicle. I received that pre-sentence report. Has everyone had an opportunity to review it?
Yes, Your Honor.
I have, Judge. Are there any additions or corrections?
None from the defense, Your Honor.
Judge, only I would like the court to know,
on the defendant's behalf. He is a veteran. He's
I
already
have
plugged in with
I've already.
with the VA. He's already working with them. So I
Good.
wanted to invite him to either come and observe our docket on June 17th, or if it would be okay with him, I will have Ms. Lowe reach out once he gets established on probation. Let him know what we have and we can help him with from that end, maybe
Yes.
even to get his probation. I would certainly agree to an early termination if the court would, if he successfully completes that after 2 years. I want to make it
Right.
available to him, but
So
I don't
there's a
want to-
veteran court program. That's a great program. That's what Ms. Molfino is talking about. And so you can go through that program while you're on probation, and it can help you with everything that has to do with your veteran stuff, in addition to what you're already doing, and it can help you get off probation early as well. So it's definitely something. Ms. Holmes can get that date and get you signed to go at least look, but I would strongly suggest you go through that program. It's a great program.
Yes, ma'am.
Okay, good. So, I'm sorry.
I'm about to say, I didn't know nothing about it. They don't really tell us this time.
Right, and it's something that kind of happens up here, and as soon as I saw, some that your duty and what's gone on with you, and that I made a notation of veteran court on here, so it's a great program. So I'm going to find Mr. Battle that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I am going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years. You're ordered to pay that $500 fine and to follow all of the rules and conditions of probation. If you do all of that, this is an excellent opportunity. You won't have a felony conviction on your record. And at the end of your probation, the case will actually be dismissed. You'll never have the conviction. The other side of that, however, is if you violate any condition of probation, then you could be back in court, found guilty of the offense, and sent to prison anywhere in that punishment range, which is between 2 years and up to 10 years in prison. So it's, again, get that information from Ms. Holmes and Ms. Malfino before you leave today. And that way you can go to that first, the one that's coming up pretty soon, and hopefully get signed up and go through that program as well. All right. I'm going to hand you the trial court certification that shows this was an agreement that I followed. And so you've waived your right to appeal. If you'll just have a seat here in the courtroom, probation is going to call you up to her desk and she's ready to go over all your paperwork. All right. Good luck to you, sir.
Give them, thank you.
500.
Give them.
Trinity Bell, Ms. Holmes.
Yes, sir.
Bill?
Yeah.
All right, I'm next.
This is going to be dismissed and refiled to a misdemeanor.
Okay. How long do y'all need reset for that?
About 30 days.
All right, ma'am, you're Trinity Bell. And this is cause number 25 DCCR 1381. I'm going to reset, just a normal reset to give you guys time to get it filed down in misdemeanor court, get that taken care of. If everything gets taken care of and you go to court down there, then you probably won't have to come back to this court date. Your case will be dismissed. Unless you hear otherwise, though, plan on being back here unless Ms. Holmes or your bondsman tells you you don't have to, okay?
Yes.
All right,
And
thank
we
you.
had one, Ms. Bell has been wearing a GPS ankle monitor for quite some time, and we were wondering if the court would allow her to have it removed, or.
Let me look real quick. I don't know that I have any notes on any issues.
Is your prosecutor gone?
Mr. Smith?
Judge, we're not opposed to it.
All right, so Ms. Bell, I'm going to remove that condition of your bond that you have to have. Well, actually, let me make sure first that it's a condition of the bond and not the bondsman.
Oh.
Because if it's their condition, that's up to them. If it was the court's condition, I can change it. And I forget to look at that sometimes and they get very mad at me. Let's see if I can figure this out.
What we would do is probably just get it posted on notice and then just mix this. I mean, they don't really do it, since we can just ask for a poster. It's a short and sweet person that's. Yeah, letter.
I don't see that I don't see it notated on the magistrate's warnings.
Price towards the judge.
Yeah. Okay.
Yeah, good. Still.
There we go. Right there where it says bonds.
It is.
It's mine. It's a court bond. Okay, so then, our court condition. Have you been going to, did you go get an assessment? Have you been going to Spindletop like you were supposed to?
No, ma'am, I lost my job, so I don't have any insurance or anything anymore.
Well, that's the nice thing about Spindletop is you don't have to have it.
Okay. Well, I did make an appointment for it.
Okay, so that was also a condition of your bond,
Okay.
that was set. And so it's very important that you still follow through with that. So even if it's gonna be misdemeanor case, you need to go get that assessment done, call and make your appointment so that you can get that done before they take care of that other stuff, okay?
Okay.
But I will remove the GPS monitoring device condition today. Ms. Holmes can tell you, y'all can talk about how to do the Spindletop thing, but I'll remove the bond condition of the GPS device today. All right? Okay,
thank
stay in
you.
touch with Ms. Holmes.
Yes.
Daniel Eli, Ms. Holmes.
Your Honor, may I approach on that?
Uh-huh, sure.
That's why I'm here. I came to talk to Ms. Holmes. We should be able, it's gonna be depending upon what happens down the hall. And I'm going to try to get that squared away. I'm not on all those cases down there, but I'm gonna take them just to move this forward.
Are you on this case?
No.
Brittany is. He passed it here.
Yeah, but we can, all that will be squared away.
Well, if he has a warrant today, we've got to.
Yes, he does.
Yeah, it's,
Daniel Eli.
I think he's outside.
I didn't know that either.
Yeah.
I didn't know that part of that.
Yeah, it's,
Didn't have to do it.
yeah, it has to do with this.
It doesn't, I mean, I just have to do, I mean, if he has a warrant, he's gonna have to go into custody here. And if y'all have a court date down there that y'all can take care of it today, then you can ask the bailiff down there to come get him before they take him to the jail, but I don't have to respond.
Yeah, that's on this.
It's at large without proper bond on your case, Judge.
Yeah.
For what though?
I don't know, I just got that this morning.
Hold on. So where is he?
He was outside.
Well, it's not anymore.
Make it do it.
If we,
So Johnny sent a message over. They hadn't, I had an email from May 5th that they had not been able to track him since April 27th, and he will not charge his GPS monitoring device.
I got that email and I called him and he was saying he was having issues with it. I said, well, go to Johnny's and get it figured out. So I told him to go there. I don't know if he,
Well, I raised his bond because of that.
oh,
that's probably not this.
okay.
I don't know.
Because I do remember seeing that.
But if
email.
I've already raised his bond, then it's not, is it a forfeit?
That's not.
Okay, all right. So he already has a warrant. His bond here is now $150,000 because of that.
Can I go get him?
You know where I mean, she just called his name. If he's here, yeah, go get him. He needs to come in.
I'll go get him.
Thank you. I'll hold it.
Okay. Body too.
And it was just because of the nature of the offense. Obviously,
Yeah.
that's why I raised it that much, because if he's not charging it and it's a family violence, that gives me concern, so. Asseston Hayward,
Aston.
Aston.
So, lesser included.
Okay, thank you. Good morning. Are you Aston Hayward? And we are client with the formal reading of the indictment.
Yes. Your Honor.
What?
Class A attempted.
Attempted. right, Mr. Hayward, in cause number 25, DCCR 1346, the state has elected to proceed on the lesser included offense of a Class A misdemeanor, attempted burglary of a building from August 29th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand if I follow the agreement that you've reached with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 2-year deferred probation. There would not be a fine, but there would be restitution in the amount of $2,620. Is that your understanding? And are you a U.S. citizen?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Hayward's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings, place you on probation for 2 years. You're ordered to follow all of the rules and conditions of probation, and you're ordered to pay that restitution in the amount of $2,620. If you do everything that you're supposed to on this probation, you get the restitution paid off. This is a great opportunity because you don't have a conviction on your record. And if you satisfactorily complete the probation, at the end, the case gets dismissed. You'll never have the conviction. The other side of that, though, is if you violate any condition of your probation, then you can be brought back into court, found guilty of the offense, and go to the Jefferson County Jail for up to 1 year. Do you understand? So $2,600 is a lot to pay in 2 years. How old are you? 8. So you're very young. It's very important that you make payments on that every single month, even if it's a little bit, because it'll add up. All right. So some people think, well, I'm going to get a better job, or I'll sell this, or I'll get my tax refund and I'm going to wait to pay it. And then all of a sudden you're at the end of your probation and you haven't paid it. If you come back at the end of your probation, you can have done everything else right and not paid that money. And if I find that you could have paid it, then you could still be revoked and go to jail even after 2 years. Do you understand?
Yes, ma'am.
Also want at least half of whatever he pays to go to restitution in the beginning. Okay. So that way I want them to get paid, the victim to get their money and get paid for what happened. Okay. That's very important to me. So I'm going to hand you now the trial court certification that shows this was an agreement that I followed. And so you have waived your right to appeal. You need to have a seat here in the courtroom. Probation is sitting at that desk right there. She's going to call you up to her desk when she's ready to go over your paperwork. All right. Good luck to you, sir. Thank you.
I need help on
And attempted. Well, attempted is always just lessens it by 1.
Okay.
You're probably, it won't have the code. It just lessens it any offense. No fine.
Thank you.
Priscilla Miller. Yeah, I don't know exactly what it is, but it's not going to have its separate thing. It's just a. So I need to remind me to take care of these people. Was Mr. Nathan back? I don't think it's gonna matter. I'm not gonna wait too much longer. I'm just gonna fall out of his chair. This is Mr. Coleman's. Thank you, ma'am. Good morning, ma'am. You are Priscilla Miller, and will your client waive the formal reading of the indictment?
Yes, Your Honor.
Oh, remind me to go back on Hayward to make my notation on that indictment. Forgot. Too many things going on at once. I'm getting there, y'all. Yes. All right, Ms. Miller, in cause number 25, DCCR 0746, you're charged with the state jail felony offense of theft of property from April 25th of 2020, continuing through October 17th of 2020. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up, please. Yes. And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Ms. Holmes? Yes. Do you fully understand them? Yes. And do you understand if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation, no fine, but restitution in the amount of $14,642. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Any evidence that Ms. Miller is not competent?
No, Your Honor.
Any reason not to go forward with sentencing Ms. French? Do you see any history?
There is none, Your Honor.
Okay, so I'm going to waive the pre-sentence report. I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings, place you on probation for 5 years. There will be no fine, but you are ordered to pay restitution in the amount of, this is going slow for me to get back.
$14,642.
$14,642. And to follow all of the other rules and conditions of probation. If you do all of that, this is an excellent opportunity because you do not have a felony conviction on your record. And at the end of the probation, if you complete the probation successfully, the case is actually dismissed. You'll never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court and you could be found guilty and sent to the state jail prison for up to 2 years. Do you understand? That's a lot of money to get paid back. It's very important that you start paying back immediately. Even if it's not very much, I want something every single month to go towards restitution. I want the same thing on this one. I want restitution and half at least to go up front. Yes, ma'am. Yeah, at least half. We can do half.
Paid, so no fees until half of restitution is paid.
No, half of what she pays can go to restitution, half can go to fees. I just want something to go to restitution on these up front. I don't want it to wait until that's all done. So that way they're getting some money up front as well. Okay, it's very important to me that that's paid. I'm not sure if you were in here, but you can do everything else on your probation correctly. And if you don't pay that restitution at the end of your probation, you could be brought back into court on a motion to revoke that probation. And if I make a finding that you could have paid it, then you could be revoked and go to prison after the whole probation. So obviously we don't want that. In addition, you have no criminal history. There is no reason that if you get that paid early, that you couldn't get off probation early. I sign early terminations for probation all of the time. So do everything you're supposed to, get it done as quickly as you can. And then it's very likely that you could get off early. Okay. I'm handing you the trial court certification that shows that this was an agreement that I followed. And so you have waived your right to appeal. You need to have a seat here in the courtroom. Probation's at that desk kind of right behind you. She's going to call you up when she's ready to go over your paperwork. Okay. All right. Good luck to you, ma'am.
Yeah, Mr. Dickinson.
Okay. Thank you. Mr. Kelly on Jeremy Chapman. Which one did I say I needed to go back to?
My name's Nelson Bell.
Y'all give me just a second to get something.
Judge, we have something to add on this one that we did not write on the tablet.
Okay, sir, are you Jeremy Chapman?
Yes.
This is 25 DCCR 1337. Ms. French, what?
We are, we did not include it in the writing, but we have agreed to an anti-prostitution class as a condition of probation. The state will provide that information to probation because they do not currently have a vendor for that class.
Okay, and that's an agreement.
Yeah.
You're gonna write that on here with everyone's permission. All right, and will your client waive the formal reading of the indictment?
Yes, we do, Judge.
Mr. Chapman, you're charged with the state jail felony offense of solicitation of prostitution from March 28th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Kelly?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a 3-year deferred probation. There would be a $300 fine. You would be required to follow all of the rules and conditions of probation, including successfully completing an anti-prostitution class. Is that your understanding?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, states 1, Judge.
It's admitted. Is there any evidence that Mr. Chapman's not competent? And is there any history or reason not to waive that pre-sentence report?
No, Your Honor.
All right, so I'm going to waive the pre-sentence report. Mr. Chapman, find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney, defer all proceedings and place you on probation for 3 years. You're ordered to pay that $300 fine and to follow all of the rules and conditions of probation, including entering and successfully completing that class. If you do everything you're supposed to on this probation, this is an excellent opportunity because you do not have a felony conviction on your record. And at the end of the probation period, if you're successful, then the case is dismissed. You'll never have a felony conviction. The other side of that is if you violate any condition of probation, you could be brought back into court. You could be found guilty of the offense and sent to the state jail prison for between 6 months and up to 2 years. Do you understand?
Yes.
I am handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. You need to just have a seat here in the courtroom. Probation's at that desk sitting right over there. Watch for her. She's going to call your name when she's ready to go over your paperwork.
All
All
right.
right. Thank you, sir.
Thank
Good
you,
luck.
Judge. Thank you.
Still no making. I don't know that you wouldn't be here. I'm just. Mr. Kimler, are you ready on Justin Payne?
Yes, Your Honor.
Good morning, you're Justin Payne. And this is cause number 25 VCCR 1358. Mr. Payne is charged with aggravated assault with a deadly weapon. And what is the announcement?
No,
Did y'all do a rejection?
no, actually, I didn't.
I'll hold it. Have a seat. You're gonna go over some paperwork with Mr. Kimler and then I'll recall your case. What about Malik Ellis?
That's a probation. Allegations.
No agreement. There's no agreement. Good morning, sir. Are you Malik Ellis? And will your client waive the formal reading of the motion? Mr. Ellis, raise your right hand, please, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? So, Mr. Ellis, in cause number 17-26733, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation October 9th of 2017 for the second-degree felony offense of aggravated assault with a deadly weapon. And that was a 7-year deferred probation that has been extended for 2 years. Is that correct?
Speak up.
And then the allegations that you violated your probation are in count 1, that you committed the new offense of possession of marijuana, Class A misdemeanor, November 18th of 2025. And is that true or not true?
Not true. Not true.
Count 2 alleges that you failed to report to the probation officer your change of address. Is that true or not true?
Not true.
Not true. Count 3 alleges that you provided urine samples March 23rd, February 21st, July 14th, and November 20th of 2025 that tested positive for THC. And on March 23rd, you also tested positive for methamphetamine. Is that true or not true?
True.
Count 4 alleges that you provided a urine sample. That's this, I don't understand count 4.
And same thing.
Mhm. You want to abandon count 4? State will abandon 4. Count 5 alleges that you possessed illegal drugs, namely marijuana, and that you were arrested for possession of marijuana November 18th of 2025. Is that true or not true?
Not true. I think you may have been arrested, but that's not a violation.
Well, it says he possessed it. He possessed illegal drugs, marijuana.
I don't know. We did be construed that he's pleading not true to being arrested.
I understand it. It's really worded kind of both ways. And so I'll just do not true for 5. Count 6 alleges that you are behind in your court assessed fees as of December 12th of 2025 in the amount of $7,031. And is that true or not true?
At the time. True. True.
As of December 12th of 2025.
True. Not true. I know that's, yeah. Right.
All right. Did you enter your pleas of true to counts 3 and 6 freely and voluntarily? And because those counts are actually true. As a condition of your bond right now, are you required to wear a drug patch? You have it on. Let me hold on. Let me look at it. That's fine. Just want to look back and make sure. Have a seat in the jury box. The last one was positive. Have a seat. We're going to get you tested. I don't know why that wouldn't. Maybe it was.
And Judge, if I may, just for the court, I've spoken with this officer this morning, Ms. Kane, before coming to docket. And so I'll have her here definitely next time.
Okay.
If you don't mind, if I could kind of keep the court in the loop about the cost benefit analysis of having somebody come from far and wide for that positive marijuana with respect to the new offense. I'm happy to have the trooper here, but it would require flying somebody from Dallas just for that. I'll keep you posted.
Well, we've got the positive drug screen.
Yes, and I think Ms. Kane has a lot to add to that. He's
Okay.
already been to ISF. He's obviously been on probation for 9 years now. And so I think we have some stuff to work with, but I'll keep you posted.
Thank you, ma'am. Hold on a second. Sorry. I'm right here. I can hear you. I can multitask. Hold on just a second though, while I think that's.
You still have to use this at after 11:30 before you can say here, he's been in another. As, oh, no, she's not going to be, I hope the bill is for the case. It's like, that's true. It's just not gonna be.
So I need to, somewhere I need to meet, but I can have someone else stand in. We reached out last time for him to get criminal history of my victim, which I gave him that day. I don't know why he can't make an announcement. Without me here. Somebody will be here since.
Yeah, if somebody else can be here, let's have them come because it's, yeah. What was his name?
He's on this mic.
That's Sean Robertson is the defendant.
Okay. Neesman. Yeah, it's getting kind of old, so I'd rather go ahead and get it, see what's gonna happen. Mr. Lewis on Presley Built. Good morning, sir. You're Presley Built. Speak up.
Yes, ma'am.
And Mr. Lewis, will your client waive the formal reading of the indictment?
He does, Judge.
Mr. Vilson, cause number 24, DCCR 2312, you're charged with a state jail felony offense of unauthorized use of a vehicle, and that's from August 1st of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with? Yeah. I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Yes. Do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 2-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes,
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection. No.
It's admitted. Is there any evidence that Mr. Biltz is not competent?
No, Judge.
And is there any history, reason not to waive that?
No, Your Honor, there's no reason not to proceed.
So, Mr. Biltz, I'm going to waive the pre-sentence report. I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 2 years, excuse me. You'll be ordered to pay that $500 fine and to follow all of the rules and conditions of probation. If you do all of that, this is a great opportunity because you don't have a felony conviction on your record. At the end of the probation period, if you successfully complete it, the case will actually be dismissed. You'll never have a felony conviction. The other side of that is if you violate any condition of your probation, you can be brought back into court. You could be found guilty and sent to the state jail prison for anywhere between 6 months and up to 2 years. Do you understand?
Yeah.
And I've handed you the trial court certification that shows this was an agreement that I followed. And so you've waived your right to appeal. You just need to have a seat here in the courtroom. Probation is going to call you up when she's ready to go over your paperwork. She's at that desk right there. So but wait for her to call your name before you go. Okay.
Yeah.
Thank you, sir. You can have a seat.
Thank you. Thank you, Your Honor.
Can you get Red Shirt to stay awake here, please? It's very sleepy this morning. What's his name? Okay. Mr. Kimler on Ebriana Bell.
Ready.
Right. Third. The day may come, but that's not today. You already said it first. Oh, sure, you should have it. What's the state of Texas on first, right? Kim, I don't think we're there yet, but
Good morning. Are you Ebriana Bell? And will your client waive the formal reading of the indictment?
So,
Ms. Bell, in cause number 25, DCCR 1610, you're charged with the state jail felony offense of theft with previous theft convictions, and that's from August 14th of 2025. The indictment alleges that you were previously convicted of theft April 7th of 2021, August 16th of 2021, and then November 10th of 2022. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? What was the result of the last one, which is a felony number?
We successfully completed deferred adjudication is what I saw here.
Okay, well, we're not doing deferred adjudication again.
Okay. After today.
No, today, we're not gonna reward the same behavior with another deferred probation.
Deferred.
I don't care what it was. You just got off probation. You were on probation 3 years ago. So, yeah. Yeah, it's a cause number 22-39877 in CDC from 2022 is the third. So this makes the fourth and the second felony. I'm not saying I won't consider a probation, but I think if I don't see any reason why she would deserve a deferred probation.
Well, it's just that, I guess, not selling her with a felony conviction.
What's stealing, you won't get a felony conviction. So I'm gonna, I'll either hold it. If y'all want to renegotiate, I'll delete the paperwork. Y'all talk for a few minutes. I can keep the paperwork and make some adjustments if that's what y'all want me to do, but I'm not going to agree to a deferred probation. All right, so I'll hold it. Go have a seat.
All right, thank you. I'll talk to you soon.
Mr. Gertz? No,
He's,
okay.
That's it.
Ms. Holmes, Daniel Eli, what are we doing on that one?
he's left. That's the one with Mr. Samuel that we talked about. We don't know where he has gone.
Okay, well, he's got a warrant, so I don't have to do anything. He's already got a warrant to hop on, so.
Yes, ma'am.
All right.
Told he had a warrant and he jetted.
Well, how about we, well, 150 is enough. Okay. I would think that might change all of the nice things that were going to happen for him today.
Yeah.
All right, thank you. Aiden Dickinson, are you ready on that sentencing? I think I might have it. I've got it. Good morning. Are you Aiden Dickinson?
Yes, Your Honor.
And Mr. Dickinson was previously in court, entered a plea of guilty in cause number 25 DCCR 1480 to the state jail felony offense of engaging in organized criminal activity. I received that pre-sentence report. Have you both had an opportunity to review the report?
Yes, Your Honor.
Yes, Chief.
Any additions or corrections?
Not from the defense, Your Honor.
So being bored got you in felony court.
Yes.
How old are you?
21 now.
Okay. So obviously, surely you look back on this and realize how absolutely stupid it was. And somebody actually could have gotten very hurt, right?
Yes, Your Honor.
That's what I just did. All right, so Mr. Dickinson, I'm going to find that you entered your plea of guilty previously freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. You will be on the high medium caseload at the beginning. That's just to make sure that you get started off in the right way on probation so that you can be successful. You'll be ordered to avoid all association. You cannot communicate, talk, have contact with any of the co-defendants, Corbin Rayleigh, Jason Weinberg, and Jaden Chandler. Do you understand?
Yes, sir.
That obviously means in person, y'all can't hang out, but that also means no contact, no sending messages, no Snapchat and DM and whatever the new things are that I don't even know about, right? If you do everything that you're supposed to do correctly on this probation, this is an excellent opportunity, especially for someone your age, because you do not have a felony conviction on your record. At the end of the probation, if you complete it and you are successful, then the case actually gets dismissed. You'll never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, you can be found guilty of the offense, and you could go to the state jail prison between 6 months and up to 2 years. Do you understand?
Yes, sir.
I'm also going to order a mental health assessment and any treatment. So we're going to have an assessment done. If there's anything that you need to help you be successful, then you're going to be ordered to do whatever it is that they say. All right.
Yes, sir.
I'm going to hand you the trial court certification that shows that this was an agreement that I followed. And so you waived your right to appeal. You need to have a seat here in the courtroom. Probation is going to call you up when she's ready to go over your paperwork.
Yes.
All right. Good luck to you, sir.
Thank you.
Okay. What is that? What's that mean? Oh. Thank you. That's. All right, Mr. Ellis, you can come back up. Mr. Kimler. All right, so Mr. Ellis tested negative, so that's good. Just continue with the drug patch. Make sure you don't use anything so that they're all negative from this point forward, okay?
I just took one and.
It's a lag time from the time it gets turned in till the time we get it. So it's been a little bit, so you're fine, okay? So we'll just reset your case for a hearing. We'll just do an 11 o'clock hearing. Should be plenty of time to take care of what we need to. Make sure you continue doing everything that you're supposed to on probation. Stay in touch with your attorney, and we'll see you back for your hearing. All right. And then Julissa Cortez Estrada.
Okay. Thank you.
Good morning, ma'am. Are you Julissa Cortez Estrada? And will your client waive the formal reading of the indictment?
Sure.
Ms. Cortez Estrada, in cause number 25, DCCR 1386, you're charged with the state jail felony offense of tampering with the governmental record from June 4th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Kimler?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine. There would be a dismissal in a misdemeanor theft case that's currently pending. And also you would be ordered to pay $500 in restitution. Is that your understanding?
Yes.
And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1. It's admitted. Is there any evidence that Ms. Cortez Estrada is not competent? Any reason not to waive the pre-sentence report? Any history?
No criminal history.
All right, Ms. Cortez Estrada, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay the $500 fine. You're also ordered to pay the $500 in restitution and to follow all of the rules and conditions of probation. If you do all of that, this is an excellent opportunity because you don't have a felony conviction on the record. And at the end of the probation period, if you successfully complete it, the case is actually dismissed. You'll never have a felony conviction. The other side of that is if you violate any condition of probation, you can be brought back into court, found guilty, and then sent to state jail prison for up to 2 years. Do you understand?
Yes.
You have your discovery certification? Okay.
So I know, you turned it, I think you already turned it in, right? I believe I said.
Okay. Hold on just a second. It sounds like we're having some printer issues over here. And I'm going to hand you the trial court certification that shows this was an agreement that I followed. So you did waive your right to appeal. And then you'll need, once I hand you that, if you'll just have a seat in the courtroom, probation's at that desk over there. She's going to call you up when she's ready to go over your paperwork. Also, so I want to make sure I want the restitution, half of what she pays to go to restitution from the beginning, please.
Bill will take the straight.
We call it in just a few minutes. You can go ahead and have, just have a seat and then we'll get that document to you, also when probation's. Mr. Gertz, you have Jose Collazo. Jose Collazo. That's
I know.
Okay.
Yeah. Right. Please, thank you. Whoops. How are you? How are you?
I'm got my passport issue resolved down the hall. We favorably and funnily.
Good.
So
No response, Your Honor?
Mr. Collazo's bonds will be forfeited in each of his case for non-appearance. Let me see that they were set out to start off with, because they set the trial, which is going to be the #1 case next week. So what's y'all's announcement if we can get Mr. Collazo?
It's ready, Your Honor.
and we can be ready, Judge. We also have an old child sex case next door too, so but we can be ready on either way. So
I feel like he won last time, so
your call.
I'll talk to obviously we need to see if you can get in touch with your client, get him here today, that'd be great.
Yep. He lives like up near Dallas. Judge,
Okay.
so it may
Maybe.
but I haven't heard anything from him.
If you'll
So and
yeah,
I've got people working on trying to get a hold of him.
okay. I'll number the case tomorrow.
That's up near Dallas. Cleveland's up near Dallas, Johnson County.
Yeah.
Okay.
Make check something real quick. I can find it.
There's Cleburne and there's Clayford County.
So this was
Which-
actually, so this was an odd thing because this was a juvenile.
Yeah, and
Okay, so I don't even know if, there's, hold on. Oh, bond, I got to click the bond name. Sorry, 20,000. All right, so I'm going to forfeit his bonds in each of his cases for non-appearance and reset them both at 100,000. Obviously, if he can get here today, I'll reconsider that. I will still number the case for trial Monday and see if we can get him between now and then.
Yeah,
All right,
Judge.
thank you, Your Honor. And then you have Larry Fletcher. Okay. Oh, it's lots of pages. All right, let me hold this for a minute so I can go through that. I did not see it. I said, no, you did. Well, I can't use this. They need, if they're gonna do a response, I need it before. No, it's not you being sorry. I don't need to. This is Mr. Coleman's case?
Yes, sir.
Are you prepared to argue?
Yes, sir.
Okay, I'm not gonna, this was filed this morning, so I'm not gonna take. come on back up. Let's just do it. All right, so you're Larry Fletcher Jr.
Yes, Your Honor.
And this is cause numbers 25 DCCR 0838 and 0839. Mr. Fletcher's charged with aggravated assault with a deadly weapon and manslaughter. There's a motion that has been filed to modify the conditions of bond. That he cannot operate a motor vehicle. And so, Mr. Gertz, go ahead.
Judge, I think you're familiar with the facts of this case because we had a hearing on a motion to revoke probation. And the issue in that hearing was about causation of the accident. And the court decided that the issue was serious enough to hold that in abeyance pending trial on of these two cases. And my request here is based on the fact that Mr. Fletcher has been following all of these bond conditions, following the rules the court set, but is having difficulty getting to and from work and doing other things that he needs to be doing to be a productive member of society. He's not allowed to drive. And so, this was not an alcohol, like it's not an intoxication manslaughter case. It's just a manslaughter. It's just an allegation of reckless driving.
The problem is the history of reckless driving. And so what the state has provided, it looks like, is that there was a 2010 non-injury crash, 2012 non-injury crash, a 2012 maximum speed limit issue, 2013 speeding over 10% over the posted, 2016 speeding greater than 15 miles over, 2018 a non-injury crash, 2021 a non-injury crash. Based on my knowledge, what was presented at that hearing, regardless of causation, there was definitely a speeding issue. That was clear from the black box in the testimony, that there was a large speeding issue. And so I am not inclined to change the bond. Mr. Nichols, does this?
That was the basis of the state's argument, Your Honor, was that his history of crashes and of speeding poses a danger to the public, and that's why we were opposed to altering these conditions.
Yeah.
Judge, we were just alerted to all of that at the same time the court was, that was filed Friday afternoon at 4:00. So.
Well, it is what it is. If there's something in there that you find that is not accurate, then just let me know, file a supplemental motion. But at this time, I'm going to do the motion to modify the bond and conditions. We'll get it set. It's already on the trial docket.
It is, Judge.
All right, it'll go back right on the trial docket. And again, if there's something that's changed that's not correct, let me know.
Okay, and I think Mr. Coleman has filed a supplemental motion to revoke probation too, which will have to be heard at some point because we're going to plead contrary to that as well.
We'll go over any motion to revoke after.
He may not have filed it yet. He may have just told me he was going to file it, but.
So. That the only two cases are on here are the trial cases, not the motion to revoke cases on our docket, correct? Yes. Okay. All right. If something comes through that I need to hear, but my thought is still to go forward with the trials first and then to deal with the probation.
I understand.
Unless there's something else significant, another new case or something.
I'm not aware of anything, Your Honor.
Okay.
Well, and let me back up and say, it's not a new case. In the wake of the motion to revoke probation hearing, Mr. Coleman filed a federal case relating to the
gun that was found.
Yeah.
Okay.
So and he's not a convicted felon, but we'll argue that when it's time to argue that. But that's what the new case is.
Okay. That was something that I've already heard in that motion to revoke to some extent.
Correct. Yeah.
Okay. All right. We'll see you back at the trial date then. Mr. Gertz on Leandre Sime or Sime? Sime?
I shouldn't fill out.
Is Mr. Macon, can you see if he's in front of the judge? Because I'll send He's not. Good morning. Are you Leandre Simi?
Yes, good morning.
And this is cause number 23 DCCR 0628. Mr. Simi's charged with criminally negligent homicide, a state jail felony. And what is the announcement?
Judge, this was a case that was on the trial docket here and then got moved to the drug court at some point, and then now, without talking about details, it's been brought back to this court.
Right.
So our request would be, Ms. Malfino and I may be able to work this out at some point, but right now, with his immigration status, et cetera, it's a necessity that we try this case.
Judge, I know that it's very old. It may be a discussion if the court would allow it. We could have off the record in the back whenever it's convenient for you. I understand the reason it came back. There are a few things I'd like to know about that too. Before we just pop it right on the trial.
Okay, that's fine. Could we maybe then put it for a review in 3 weeks or something?
Yeah, let's do that. Let's do about 3 weeks and a reset on a review, and you guys.
Can it just be a review that he has to come all the way in from Florida? So is it the kind of thing that we could do a review and just note that he doesn't need to come from Florida, or does he need to come back for that?
Well, if we're gonna put it on the trial docket at that point, I'll need a rejection. So I don't know if y'all wanna.
We've done a rejection previously, I believe, Judge.
See.
You don't see it? Yeah. It's not.
Because of the
I know.
expiration.
But they also, yeah.
It's fine, Judge. He'll comply with whatever. I mean,
I can do 4 weeks. I can do a normal reset if that
That's fine.
helps. And then let's just do a normal reset, and then we'll get all on the same page on that date. Okay?
Thanks, Judge.
All right. Mr. Kimler on Ibriana Bell, recall that? Oh, Mr. Wilkerson, I'm sorry. Hold on just a second. Mr. Wilkerson?
Good.
Hold on, just, sorry about that. On Ramon Artola Jr.
Yes.
That's not.
If you mind doing me a favor, would you go see if you can hunt down Mr. Macon in another court and tell him we need to get him taken care of? We don't see that he's in front of Judge Stevens right now, but I'm not sure. Do you mind? Thank you so much.
Gotta go down to the other CCL court.
If you see him, please tell him we need to take care of his, it won't take long.
Yes.
Raymond Artola.
No response, China.
All right, his bond will be forfeited for non-appearance and reset at 100,000.
Thank you.
All right, thank you. Thank you. Mr. Kimler now on Ibriana Bell. All right, ma'am, you're Ibriana Bell again, correct?
Yes, ma'am.
And we've already gone through that she entered a plea of guilty. Well, actually, let's go back because I don't even think I went too far with all of that. Will she waive the formal reading of the indictment?
Sure.
So, Ms. Bell, in cause number 25 DCCR 1610, you're charged with the state jail felony offense of theft of property with previous convictions from August 14th of 2025. And how do you plead to that charge? And then your indictment alleges that you were previously convicted of theft of property April 7th of 2021. After that was final, August 16th of 2021. And then after that, November 10th of 2022. And are those true or not true?
True.
Did you enter your plea of guilty and true to those allegations freely and voluntarily?
Yes, ma'am.
And did you plead guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And what is the agreement that you guys have reached? And is there any issue with me changing the agreed punishment recommendation page to reflect it?
Your Honor, we've agreed on a straight probation of 2 years and state jail probate over 3 years with a $500 fine, $221 restitution.
Correct, Your Honor.
And I have no objection to the court making those changes.
That's the current agreement, Your Honor, is reflected in the altered or corrected punishment recommendation, agreed punishment recommendation.
All right, so what the agreement is for a 2-year term in the state jail prison, that would be probated for 3 years. You would be ordered to pay a $500 fine as well as restitution in the amount of $221. Is that your understanding?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No, Judge.
It's admitted. Is there any evidence that Ms. Bell is not competent?
None, I'm aware of it.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That's going to give me more information about you, your case, your history, and then we'll come back later for sentencing.
Yes, ma'am.
You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there.
Yes, ma'am.
All right, we'll see you back at sentencing. Miss Bell. Hey, Miss Bell, come back for a sec. If I test you this morning, you gonna have anything in your system?
No, ma'am.
Okay, just double check that, okay? Have a seat right over there so I know for sure. Justin Payne. Shining.
Houston County Court 2, it was advised.
Okay, thank you very much. All right, so you're Justin Payne. And Mr. Payne, in cause number 25 DCCR 1358, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon. And that's from September 5th of 2025. And what that means is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand? And I have here on the tablet a plea bargain rejection that you've signed with Mr. Kimler that shows that the district attorney's office has made an offer. If you wanted to enter a plea of guilty for a 10-year deferred probation, there would be a $500 fine. You have every right to reject that. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to enter a plea of guilty. And do you understand all of that? Speak up.
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes.
Is there any reason, Mr. Smith, for that you know of that offer would change?
Judge.
Any evidence that you're waiting on? All right, so I want to make sure you understand, Mr. Payne, that after today, I will not accept this plea agreement unless there is new information that your attorney or the district attorney doesn't have right now. So if you want to go to trial, we'll get your case set on the trial docket. We'll let a jury decide. I just don't want you to place it on the trial docket thinking that somehow it's going to go away or it's going to get better offer. Do you understand?
All right. Always a chance.
Well, I mean, it can get dismissed, but that's not on the table right now, and I won't accept this later. You understand? And do you want to go forward with setting your case for trial? All right, we'll get it set on the trial docket. Stay in touch with Mr. Kindler. He'll begin preparation for trial, and we'll see you back on the trial date. Yeah. Okay. So we're waiting on Mr. Macon, we're waiting on Mr. Neesmith and Mr. Reynolds. And then I'm getting Ms. Bell drug tested. I think that'll be it. We can get Mr. Wars rousted awake again. Rousted, is that a word?
It is. Hey, how did we do on the front list?
Oh, as expected.
Oh.
It's messing with you now, you know, you call them.
All right, this is cause number 25 DCCR 1253. Mr. Wars tested positive for THC, methamphetamines, amphetamines, and ecstasy MDMA. So we are here on a sentencing. Obviously, he's not in a position today to understand the sentencing. So what I'm going to do at this time, I'm not going to reject the offer. There might be some things still that would be considered because of the nature of that offense with the probation, but I cannot obviously do it with his current state of mind. So I'm going to revoke Mr. War's bond based on the nature of the offense, which is a driving while intoxicated third or more. How'd you get here today? You got a ride or you drove? Okay. So I'm going to revoke the bond. At this time, there will be no bond. I'm resetting the case till next Monday for sentencing. And then I'll decide at that point whether or not I follow the agreement. And if so, Tuesday, he'll be in custody. Tuesday. I'll reset the case for next Tuesday for sentencing. And then if I go along with the agreement, I'll figure out what additional conditions, which I already had.
PSI recommended ISF.
ISF already, but it might be something a little more lengthy than that. Go with the bailiff. Thank you.
Judge, I can get with the counselor to let her know about today
Okay,
and see if there might be.
something different. It was ISF substance was recommended, but just based on this, he's obviously in a terrible position. He tested positive at the PSI as well. So maybe Safe P would be something that would be a little more
Or a nap.
a long nap. He's about to get a nap. Miss Bell, come on back up.
Y'all have a nice day.
Everything okay?
Yeah, I'm not even in my system.
No, you don't, but you also don't have a bad attitude about me checking, okay?
Yes, ma'am.
I check it different people for different reasons. There's no reason to have an attitude. And there's definitely no reason to have an attitude with the nice lady that's standing behind you.
I have an attitude.
Okay, all right. So you tested negative, that's great. And so I'm going to reset. I can't remember now what we were doing on your case, but
PSI.
okay. Stop and talk to probation on your way out, and we'll see you back at sentencing.
Why?
Hey, Mr. Reynolds on John Tat Taylor. Come on up, Mr. Taylor. Good morning, sir. You're John Tat Taylor.
Yes, ma'am.
And this is cause number 25 DCCR 1427. Mr. Taylor's charged with fraudulent use or possession of credit or debit cards. And Mr. Reynolds, what is the announcement?
Judge, we received the discovery in his case. He lives in Fort Worth. He has not been by my office so I could review it with him. I received an offer from the district attorney. I don't want to reject the offer till I'm able to go over that with him and ask maybe for a 30-day reset. Let us get that done.
So, Mr. Taylor, I'll reset your case a normal reset, which is about 30 days. You need to make an appointment and visit with Mr. Reynolds before that next court date. If you can do it while you're in town, great. If not, you're going to have to make a trip to come visit with him so that we can know what to do with your case next time, okay?
Yes, ma'am.
All right, you're free to go. Thank you.
Okay, thank you.
Thanks, Judge.
Let me know. Is it okay?
Yeah, and thank you, sir. And ma'am, you're Deshaun Robertson. This is cause number 25 DCCR 0914. Ms. Robertson is charged with aggravated assault with a deadly weapon. And what is the announcement?
Yes, Your Honor, we have no announcement today. However, we're requesting a push from the court to give a mitigation packet to the prosecution in this case.
What do you mean a push from the court?
An extra date.
I think a reset, Judge. Mr. Naismith has advised me he is preparing a mitigation packet for Mr. Nichols and would like to sit down with him and discuss in person some things that may change the offer. The offer now is a pen time offer, not a probation offer. There is a cap made in the case. So I don't know that mitigation packet may either alter the offer or help Luke explain the cap to you, counsel.
Okay, so what I'll do, it looks like you filed a notice of representation back in December.
Yes.
So this will be the final reset for an announcement.
Yes, ma'am.
And so on that date, either it gets taken care of with the plea, or at that point, there'll need to be a rejection of any offer and it'll move to the trial docket.
An announcement that day as well. Rejection announcement that day too.
Yeah,
Well, I'd explain to him when it goes on this court's trial docket, it is intended to be a trial.
yes. Yeah, there's no putting it on the trial docket and it not going to trial. It either goes to trial, or if there's some different negotiation, it would be because there's new information. I don't take the plea agreement after that date.
Yes, ma'am.
So once it's on the trial docket, it's either a trial, or if it's something different, it's because there's more information that's for some reason y'all didn't know.
Yes, it was a HIPAA release. I took care of that 5 days on that.
Okay.
For our mitigation packet, I'll get it to you.
Okay, sounds good. Then we'll just do a normal reset. Obviously this should have been taken care of quite some time ago. I know Ms. Holmes sent you an email back in April.
She did.
That we needed that. So there will be no reason, that cannot be a reason for another reset.
No.
I'll get that signed today for that investigator.
In this
but
tense
it's,
courtroom
it
session,
won't be a
a
reset
judge makes
based
it
on that,
clear
okay?
that
Yes, ma'am.
second
All right, stay in
chances
touch
are
with your
running
attorney.
out
He'll let you know
as
when you need to be
defendants
back.
facing
All right,
serious
thank you.
criminal charges return to court looking for more time. One defendant, charged with a repeat intoxicated driving offense, appears before the court hoping to move forward with a plea agreement. But after reviewing the circumstances and the defendant's recent behavior, the judge abruptly changes course. Concerned about public safety and the defendant's current condition, the judge revokes his bond and orders him taken into custody immediately. The courtroom grows quiet as the judge explains that sentencing will be postponed and that he is no longer certain he will accept the proposed agreement. Instead, he wants additional time to consider stricter conditions and treatment options before making a final decision. What began as a routine hearing suddenly becomes a dramatic reminder that judges can reject plea deals and impose additional restrictions when they believe a defendant remains a risk to the community. Later, the court turns to several other criminal cases involving missed deadlines, delayed negotiations, and unresolved plea offers. One defendant, facing fraud-related charges, is warned that he must meet with his attorney before the next court date or risk losing opportunities to resolve the case. Another defendant, charged with aggravated assault, requests yet another delay while his attorney prepares a mitigation package in hopes of improving a plea offer. This time, however, the judge draws a firm line. She warns that the next setting will be the final reset, and that if no agreement is reached, the case will be placed on the trial docket. Her message is unmistakable. Once a case is set for trial, the court expects it to move forward. What starts as a routine docket day quickly turns into a courtroom lesson about accountability, preparation, and the consequences of waiting too long to make critical legal decisions. Question: do you think judges should give defendants multiple opportunities to negotiate plea deals, or should cases move to trial sooner once delays begin piling up? Like and subscribe for more real courtroom moments.